defendant claims that he's trying to avoid any delay, but at this point, we're on the 8th attorney, I believe. Morning, Melanie, Marland, and Colleen Baharav for the state.
All right, thank you. What page?
18.
All right, so this is Mr. Bellisario's motion for substitution of counsel due to public defender's failure to communicate, failure to file appropriate motions, and refusal to address the bias and corruption of Judge Crystal Eller. And my understanding is the state needs to make some representations.
Just a few, Your Honor. I just want to point out that we've had a lengthy and kind of tortured procedural history in this case. I will note I was initially on the case when I went out on leave in December of 2022. This case had been pled. The defendant pled guilty via Alford. He was moving to withdraw, so we continued it. And when I came back from leave, it turns out that this case is still going on. And here we are 2 years after the defendant entered his Alford plea in June of 2022. And we're still getting some delays. The defendant claims that he's trying to avoid any delay, but at this point, we're on the 8th attorney, I believe, on the case. 4 of them were retained, 4 of them were appointed. I understand the defendant has had supposedly issues with each of these attorneys who are refusing to file the motions he wishes them to file. That said, Nevada Rule of Professional Conduct 3.1 specifically notes that a lawyer shall not bring or defend a proceeding or assert an issue therein unless there is a basis in law and fact for doing so that is not frivolous. It appears as though every single attorney has disagreed with the defendant's version of events in terms of filing certain motions. My understanding is Mr. Arnold had filed a motion to withdraw a guilty plea, which did not meet Mr. Bellisario's exacting standards. Ms. Border, I believe, was in the process of filing a motion to withdraw a plea of her own. And now the defendant is trying to, again, get a new attorney. Now, while the defendant is entitled to an appointed attorney, he is not entitled to an appointed attorney of his choice. He has a public defender, which he's been requesting for some time. At this point, I understand if the court wants to have a young hearing to determine whether there's an issue that would be such as would warrant, again, another attorney. That said, I would just point the court to the defendant's intentional delays in this case, which is what the state believes. This has been going on. Every time there's a hearing that's set either for sentencing or for the motion to withdraw plea, all of a sudden there's a new attorney that comes onto the case, new motions that get filed. Mr. Bellisario is an attorney in his own right, or was an attorney in his own right, and seems to know what he's doing. If he's having such issues with his attorneys, I do believe that at some point he is not entitled to an indefinite number of appointed attorneys. So if he chooses to represent himself, I believe that's something he's more than able to do, but he has a very competent counsel now, Ms. Border. So I just want to put the state's position on the record, that being that we do believe there's some intentional delay. If Ms. Border is willing and able to file the motion that she, I believe, has prepared, there's the motion to withdraw a plea that the defendant wanted filed. And the court at this point can just set either a hearing on the motion to withdraw a plea or a sentencing hearing. I think at some point we need to get this case moving, because we are almost reaching 2 years since the defendant entered his Alford plea. And at some point things need to move, and the defendant cannot keep intentionally delaying this proceeding. Again, he is not entitled to appointed counsel of his choice, and that's what the defendant is trying to get. He's not happy with each of his attorneys, and every single time there is some reason he wants something filed. And with that said, Your Honor, again, this is the 8th attorney, and I just wanted the state's position to be on the record. I know the court will have its own young hearing outside the presence of the state. But I would be requesting that we either get a motion to withdraw plea set, and we can argue it, or set a sentencing date.
So, Ms. Border, you haven't filed a motion to withdraw a plea yet?
No, Your Honor, because this is Mr. Bellisario's motion today, to make no representations. I have a file.
Is it prepared?
Filed.
Is it finished?
Prepared. It is finished, but it has not been shared.
She never contacted me with.
Okay, hang on. It is not your turn to talk. You know how this works. Hang on. I'll get
talking about my.
You know, I'm going to get to you. It's not your turn. Okay. So, state, if the motion was filed soon, would you be able to respond in time to have the hearing on June 6th? Because I already have a hearing set for June 6th.
Absolutely.
Okay. All right. That's all I needed to know. Thank you. I'm going to trail the case right now for the Young hearing to finish the calendar, and then we'll call you last.
Oh, it's today?
Yes.
Okay, Your Honor, I may need to reference notes that I have in our internal JustWorks system. I didn't realize it was on for a Young hearing. I can certainly go back to the office and print.
Do you want to do that, or do you want to move it
Well,
to,
Mr. Bellisario is here
Thursday?
today. I don't want
I
to
agree.
inconvenience the court.
if
or
you're going to be
so-
prepared, if you're prepared, if you can be prepared, we'll do it. If you need more time, we'll do it Thursday.
No, Your Honor, if we're comfortable today, I can just run back.
I say let's
to
do it Thursday.
Pardon?
Let's do it Thursday. I have other things I have to do, so I can't be here all day.
Okay, no, we're going to do it today. Okay, you obviously you've filed your motions. They're thoroughly documented, so I know you know what you're ready to say, so you don't need any more prep time. And we'll just trail it to the end so we can have the Young hearing.
Do you need the state to remain outside or do you want to contact us to come back?
You guys can leave, and if we need you to come back, we'll call you. All right,
Thank you,
thanks.
Your Honor.
Page 18, State of Nevada versus Bellisario, C 354165.
Okay, and again, this is Mr. Bellisario's motion for substitution of counsel due to public defender's failure to communicate, failure to file appropriate motions, and refusal to address the bias and corruption of Judge Crystal Eller. This will be a Young hearing, so it will be sealed and it will be confidential. So at this time, anyone who is in the courtroom must leave, and anyone who is watching on Zoom will be muted and excluded from the hearing.
Alex here. If you guys have been watching the Bellisario series since 2022, then you'll know the Young hearings are so confidential that even the prosecution is removed from the courtroom. The District Court Judge Crystal Eller conducted the hearing, and she rendered a decision by minute order. And in that order, it indicates that she denied Mr. Bellisario's motion for substitution of counsel.